As far as the verdict rendered by the Supreme Court today is concerned, there are two important facets of the Supreme Court's decision. Now, as far as the Supreme Court's enunciation of the constitutional principle that elections are to be conducted in 90 days from the dissolution of a provincial assembly is concerned, there is and there was never any ambiguity in this respect. The constitutional principle that elections are to be conducted in 90 days is categoric, and allowing elections to be delayed based on any tenuous reasons would perhaps set a dangerous precedent whereby elections may be postponed for any reason in the future as well. So, as a result, I believe the Supreme Court's enunciation of the constitutional principle that elections are to be conducted in 90 days is uncontroversial, and there was perhaps never any doubt in this respect. In fact, we may appreciate that when a 9-member bench had initially been constituted to hear petitions with respect to the delays in these polls, even during the hearing of that case, no judge of the Supreme Court had ever questioned the fact that elections are to be conducted in 90 days. Nonetheless, we also have to remember that the Supreme Court, being a constitutional court, is obliged to dispense justice in accordance with the law and the Constitution. And I believe this judgment perhaps raises a number of questions about the contours of the Supreme Court's original jurisdiction and the manner in which judges who had a different viewpoint than that of the Chief Justice, the manner in which their views were dampened by excluding them from the adjudication of this case perhaps raises more questions. And the manner in which the court has heard and then decided this case perhaps raises a number of questions not only about the integrity of the electoral process, but also about the integrity of the court itself. While given that the Supreme Court is the final arbiter of the law in of disputes such as this, the government's options now appear to be rather limited. The government may prefer a review petition before the Supreme Court, but the review petition would be heard by the same bench, and as a result, the government's chances of success are rather limited. The other option perhaps available to the government would be to completely and flagrantly flout the order passed by the Supreme Court. Nonetheless, not only would this option be completely unlawful, but the ramifications of exercising this option would be catastrophic. Not only would such a decision escalate and aggravate the tensions between the executive and the judiciary, but if the government, for instance, refuses to release the required funds to the Election Commission or deploy the required security personnel for the elections, we are going to be in a situation where there's going to be more political uncertainty and where there's going to be an extreme conflict between the executive and the judiciary. So perhaps the only reasonable option left for the government is to implement the Supreme Court's decision. But nonetheless, my analysis would be that the government would continue to mount political and legal pressure on the Supreme Court. We have seen in the recent past that the PDM government has also built a narrative about the Supreme Court. I think we will see an escalation of that narrative, and perhaps we will also see the government filing a review petition and once again asking for the constitution of a full court to hear that review petition.